I'm attorney Brian Williams, and today we will briefly discuss in absentia removal orders and what a person can do if they've been ordered removed in absentia. If a respondent does not appear for a hearing in removal proceedings, the immigration judge will usually enter an order of removal in absentia. In absentia means without the respondent's presence in court. A respondent in removal proceedings must attend, on time, every hearing that is scheduled. If they run into problems getting to court, it's important to call the court to let them know that they will be late or unable to attend. Sometimes the immigration judge will allow more time to allow the respondent to arrive, but if they do not, calling can still be helpful if a motion to reopen needs to be filed. A person who has been ordered removed in absentia will be taken into custody and removed from the U.S. without a hearing in front of an immigration judge as soon as they encounter an officer from Immigrations and Customs Enforcement, ICE. The in absentia order makes the respondent inadmissible and also ineligible for certain types of immigration relief for 10 years. The respondent will be ineligible for adjustment of status, change of status, cancellation of removal, and voluntary departure. So, what can be done if a person has been ordered removed in absentia? A motion to reopen is a request to restart the removal proceedings. Motions to reopen can be based on lack of notice or based on exceptional circumstances. If the immigration judge grants the motion to reopen, the respondent is able to pursue any immigration relief that they are eligible for. Filing a motion to reopen gives the respondent an automatic stay of deportation, which means that the government cannot remove or deport the respondent from the U.S. until the judge has ruled on the motion. If the motion is based on lack of notice, the respondent will need to prove that they did not receive the notice to appear or whatever hearing notice that they did not receive. There are no time restrictions on filing motions to reopen based on lack of notice, and the government does not charge a filing fee. There is a presumption that the hearing notice was received if the government can show that they mailed it to the respondent's last known address by regular U.S. mail. It's important for a non-citizen to inform the government within 5 days of moving if they change their address. If the notice was mailed to the correct address but not delivered for some reason, the respondent can prove that they have problems with mail delivery. Usually, affidavits regarding mail delivery or showing a history of failed deliveries will be used to prove that the mail was sent properly by the government but was not received. If the respondent has an attorney who has entered their appearance in the removal case, service on the attorney constitutes service on the respondent. If the attorney has received the notice and failed to notify the respondent, the immigration judge will not grant a motion to reopen based on lack of notice. In this situation, the motion to reopen would be based on exceptional circumstances. The respondent would need to make a claim of ineffective assistance of counsel that amounts to exceptional circumstances. If the basis for filing a motion to reopen is exceptional circumstances, it must be filed within 180 days of the removal order, and the government charges a filing fee of $110. Things like serious illness, death of a family member, or issues outside of the respondent's control, like weather or traffic accidents, can qualify as exceptional circumstances that would cause a judge to grant the motion to reopen. The judge will consider the totality of the circumstances to determine if a respondent's reasons for missing the hearing constitute exceptional circumstances. Totality of the circumstances just means that the judge will consider all available information. If a person is not eligible to file a motion to reopen, they can request discretionary relief from ICE. Discretionary relief means that ICE is not required to grant it, it's their option. The respondent requesting discretionary relief must state their case for why it should be granted. The immigration judge is not involved in this process. The respondent makes their case directly to ICE. If granted, the removal order would remain in effect, but ICE will refrain from deporting the respondent. ICE also has the right to terminate the relief at any time. Deferred action is granted if there are compelling humanitarian reasons for allowing the respondent to remain in the U.S. serious illness that requires treatment in the U.S., or some other issue that convinces the government to delay removal will need to be proven for ICE to grant discretionary relief. Deferred action can only be granted for 2 years at a time, but can be renewed indefinitely. A stay of removal can only be granted for 1 year at a time, but can also be renewed indefinitely. If a stay of removal is granted, the respondent will be placed on an order of supervision, meaning that ICE can require occasional check-ins. If a respondent is awarded deferred action or a stay of deportation or removal, they are able to get employment authorization. An in absentia order of removal is a very serious issue and needs to be corrected as soon as possible. If you have an in absentia order of removal or any immigration problem, please call me at 301-891-8485 or visit my website at www.brianwilliamslaw.com.